In the most recent step in the continuing dispute, both Ripple and the SEC have each answered the other's applications for summary judgment. Earlier, applications for summary judgment had been submitted by both Ripple and the Securities and Exchange Commission. If accepted, a judge would then make a decision on the case, avoiding the necessity for a trial. However, on Friday of last week, each party submitted a separate move to dismiss the other's request for summary judgment. The SEC stated that there is undisputed evidence that Ripple offered unregistered securities without authorization and that the motion should be denied. On this premise, the federal regulator filed a complaint against the corporation in December 2020. Ripple asserted that the SEC lacked the legal authority to demand that it register XRP as a securities. Prior to this, Ripple disclosed in the disclosure of specific documents that it had made up to 6 requests. The SEC made these observations regarding the alleged Hinman documents. They allegedly make public SEC remarks regarding a lecture given by William Hinman, a former director of the Corporate Finance Division. In his lecture, Hinman stated that although he had previously thought of Ethereum as a security, he has since come to the conclusion that current offers and sales of Ether are not securities transactions, after learning more about the blockchain-based transactions. In order to prove that the SEC is aware of Hinman's assertion that Ethereum is not a security, Ripple requested the publication of these notes. Applying a similar logic, Ripple thinks this will support their argument that XRP is not a security. Regardless of how prestigious Ripple may be, a legal expert contends that the viewpoint of a former SEC official is probably unimportant. He contends that the Supreme Court, which has consistently upheld the Howey test standard, still has the final say. This criterion effectively defines a security as an investment of money in a shared venture with a reasonable expectation of profit to be obtained from others' labor. SEC Chair Gary Gensler thinks that most cryptocurrencies would qualify as securities under this criteria. One major exception, which he claimed would be considered a commodity, is Bitcoin. However, another research found that several XRP holders had provided affidavits stating that this was not the reason they had made their purchases. Buyers of XRP did not expect profits to come from Ripple, but from market movements or other sources, according to Exhibit 167 of Ripple's motion to deny the SEC. Even while it has nothing to do with the litigation, it's important to note that the chief developer of the XRP ledger has resigned. Nick Bougalis declared he would stop working in blockchain and cryptocurrency, but he did not say what he would do in its place. This is the most recent resignation from a company by a prominent crypto personality. Gavin Wood, a co-founder of Polkadot and Ethereum, announced last week that he would step down as CEO of Parity Technologies. Cameron and Tyler Winklevoss, co-founders of Gemini, resigned from their posts as directors on the board of Gemini Europe last week, according to a filing. Late in September, the CEOs of the Celsius Network and Kraken Bitcoin exchanges both announced their resignations.